Hi. So, as a few of you may know, I received a parking charge notice from not paying a ticket in a council park, public owned car park. And I wanted to see how far I could take it and what actually happened. And I live in Scotland and the legislation is slightly different, so I needed to find out exactly what happened. So I received several letters asking me for payment for £30, which I just sent back, returned to sender, no contract kind of thing. And then I actually sent a letter to a man called David Brown, who I'm sure is a very nice gentleman, just explaining I've not paid any monies because A, you have provided me with no evidence that I broke any law. B, you have provided me with no evidence that I have to pay any fines or forfeitures. And C, you have provided me with no evidence that a valid contract exists between us. In private car parks, you'll often see terms and conditions and you sort of consent to those, although they're still dubious. But council car parks, you notice there are no terms and conditions. It just says penalties if you park slightly wonky or you leave a bag in your car or something like this. So on receipt of this evidence being provided by yourselves to me within 7 days, I conditionally accept, very important statement, to pay anything due to you. If no evidence is provided, I believe this is likely to be a scam, therefore no monies will be transferred to safeguard me against fraudulent activities by your company. Please also be aware that any more letters received from yourselves that do not pertain to the above request will be subject to a £50 charge as per my fee schedule. Regards. So then I received this, a charge certificate, probably otherwise known as a liability order in England, but it's, whoa, look at this, oh my god. So, liability for the penalty charge lies with you, the owner, keeper, hirer. You are the registered... So notice to owner, as the penalty charge not been paid in full and in accordance with Road Traffic Act 1991, which is true, I have read this. The amount of the penalty charge has been increased by issue of this charge certificate by 50% to £90. Now the original charge was £1. £1, £1. And it's now 90. That's a 9,000% increase, I think. So I sent them this. You must not ignore this notice. A letter sent to you regarding this matter over a month ago has been completely ignored. Surprise, surprise. And I've not paid any monies because blah, blah, blah. Oh! 5 Council. Road Traffic Act. That's his evidence, the Road Traffic Act. Okay, yeah. Well, I was not acting in a commercial capacity on the day I parked, so I don't think it quite applies to me, but I don't think you really understand that. Thank you for your recent correspondence regarding the... Now, I must just say here, this is nonsense. A letter sent to me, and they say that I sent them a load of stuff with stuff on the front saying, with no legal standing written below, blah, 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 £90, blah, 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 and charge certificate. Failure to make payments will result in the council instructing sheriff officers to recover the outstanding debt. 2 things there. Sheriff officers. We'll find out about that later. Outstanding debt. There is no debt. And if there was a debt, if in big neon letters, if there was a debt, it was for £1 that I never paid in the first place. How you understand my debt to be £90 is beyond me. I don't know. I then sent a letter back to him telling him just to leave me alone. Leave me alone. And it was basically said, stop sending me stuff. And it was quite legally done, And then I received a letter back from them saying, thank you for your recent correspondence regarding the above PCN. The letter which we received has no legal standing, and makes no sense. And I would advise that any further similar correspondence will not be acknowledged or responded to by 5 Council. So they're at the point now where they are that child in the school ground going, when you ask them a question, you say, just tell me what you did. And they go, I can't hear you. Just tell me. Please just tell me, I can't hear you. I can't hear you. I'm 5 Council. I can't hear you. Totally immature. Really? Come on. I've asked for evidence. I've just said here, just send me the evidence, please, that I need to pay. No. So then I wrote back to him. Dear Mr. Brown, thank you for your recent correspondence regarding the above penalty charge notice. The letter I received has no lawful standing and makes no sense. I would advise that any further letters from yourself or your company will not be acknowledged or responded to by myself unless they show the evidence asked for in this letter. I will be happy to settle any financial obligation I might lawfully have with your company as soon as I have received proof of claim against me from you by way of the following documentation. 1. Validation of the debt, i.e. the actual accounting showing 5 counts of real losses. In law, in order to pursue a penalty, you have to have incurred a loss. Not paying £90 that's not a loss, it's just maybe they haven't incurred a gain. Verification of your claim against me, blah, 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 Bills of Exchange Act, a copy of the contract, no contract. I hereby give you 14 days from the date of this notice to reply to it with a notice. Sent using recorded post and signed under full commercial liability and penalties of perjury, assuring and promising me that all of the replies and details given to the above requests are true and without deception, fraud or mischief. Your said failure to provide the aforementioned documentation within the said 14 days to validate the debt will be taken to constitute your agreement by acquiescence to the following terms. Now, I did get this off of, someone who knows a little bit more about this than me. But all that work, that's all me. I did all that by myself. Right? The debt is, in fact, either invalid, did not exist, any damages, blah, blah, blah. So then I receive this from Scott & Co. Sheriff officers and messengers at arms. Right, okay. So, we are instructed to enforce the undemoted charge certificate issued in terms of Road Traffic Act. Again, doesn't apply to me because I wasn't acting in commercial capacity. You should be aware of the charge certificate. Now, you look... They can arrest my earning, arrestment of my earnings, arrestment of funds in my bank account, attachment and auction of my effects. Oh, I love these cars so much and they're going to take them from me. Right at the bottom there, you'll probably see there, it says Scott & Co. LLP is a limited liability partnership registered in Scotland under registered number. Debt collectors, no power of the court. So I thought, Mr. Brown, he's probably sat there laughing, thinking, ho, I got him. Now he'll be sorry that he never paid his £90. So I thought, nah, I need to put him into checkmate. I need to write him a letter so he knows that I know that I've won whichever way this goes. Dear Mr. Brown, having this morning received a letter from a debt collection agency, not sheriff officers, Stephen Baldwin, that's me, I write my name in capital letters, that's the legal fiction, is requesting verification from you personally that any alleged financial liability to Fife Council has now been terminated. Would you inform of this termination of liability in writing, please? This will arrest any dispute that the two parties may or may not still have and clarify the status of the contract. Would you inform if any alleged financial dispute, brackets, between me and Fife Council, close comma, brackets, has or has not been resolved financially by Scott & Company, the third party interloper in this matter, i.e. if the alleged debt, in them square bracket things now, to Fife Council has been sold, because that's what they do, they sell debts for about 1/10 of the price, then debt collection agencies come round and still try and get the full amount off you. Oh my God, that's so unlawful. But it's legal. Oh my God. But let's not worry about that right now. If this is the case, the debt has been paid and therefore no longer exists. So no further liability can be placed upon either by yourselves or by third-party interlopers. He's going to read that and he's either going to think, oh my God, that guy is a total nutter, or he's going to realise that all along I was right. I've placed him in check. Whichever way he moves, he's lost. Because if he states that the council still have liability, then the third party shouldn't be getting involved. If a third party is getting involved, then the financial liability to the council is over. And because the debt has been paid by these mugs, it's finished. It is finished. And I did actually write to the Scott & Co just to make them aware that I don't consent to any of their actions, and my car is completely out of bounds. They can't clamp it according to Regulation 4 of the Taking Control of Goods Regulations 2013. So we'll see what happens. I'm sure these people will knock, but there's no law that says you have to answer the door. So let's see where this goes. It's very exciting, and don't be afraid of these people. They have absolutely no authority or control over you whatsoever. Okay, thank you. Good night.